Just a reminder, this meeting is being recorded for the benefit of your classmates who couldn't be here, or in case any of us would like to watch it again. This is Module 2 in the contracts course. Our topics for this week, we're going to talk about the third element of a contract. The first two elements were offer and acceptance. This week, we're going to talk about consideration. We're going to talk more about paralegals creating an intake form based on a client's written contract scenario. We're going to rewrite contract terms based on the intake form. We're going to correct defective terms using the intake form. We're going to research possible remedies, what our client's remedies are when our client has been in a breach of contract situation. Any questions before we get started? Christy, Melinda, or Valeria? Fantastic. This is our introduction to the Uniform Commercial Code. What is the Uniform Commercial Code? Well, we designate two types of contracts. One are contracts for services. The second type are contracts for the sale of goods. We call goods movables. Anytime someone purchases a computer or purchases a table, that would be a movable. Contracts for the sale of goods are something that we want to uphold. Those kind of commercial contracts, they're very important for the economy. That the sale of goods and that the stream of goods, through commerce continues. So we have some more flexible rules that apply to contracts for the sale of goods. They are in a code known as the Uniform Commercial Code. Article 2 deals specifically with contracts for the sale of goods. I believe it's over $750. Most states have adopted most of the provisions of the Uniform Commercial Code. As you know, there are 50 states in the United States, which each have their own statutes, their own common law, their own state legislatures drafting laws. Every state has its own constitution. So states do have the authority to make special laws, but most states have adopted the Uniform Commercial Code. A contract, when the contract is put in writing, the parties may specify that the Uniform Commercial Code applies, whether they specify it or not. If it's a contract for the sale of goods greater than $750, for example, the Uniform Commercial Code will apply. The Uniform Commercial Code has special rules for what remedies are available to buyers and sellers if there's a breach of contract. Let's talk about some of those remedies. So again, before we do though, I just want to clarify that we're talking about contracts for the sale of goods. Let's look at something that is not a contract for the sale of goods. For example, if your mom hires Britney Spears to sing at your birthday party, or if your mom hires Alicia Keys to perform at a New Year's Eve party, that is a personal service contract. There is not a sale of goods involved. There might be a piano involved, and that is a good, but the piano is not what we're contracting for. We're contracting for the services of an artist. If you contract to have your roof repaired, that is a service contract because you're purchasing a service. You're not purchasing a roof, you are purchasing the service of having your roof repaired. You might be contracting to have your house repainted. You're not buying paint, you're purchasing a service. So the UCC does not apply to contracts for services. It only applies for contracts for the sale of goods, movables, like if someone purchases a car on eBay, if somebody buys a boat, those are movables, those are items. If someone buys nails for a construction project, if somebody buys hammers, if somebody buys doors and walls, things like that, those are goods. So the UCC would apply. So usually the parties to a sales contract owe a duty to perform the obligations that are specified in their agreement. And that is UCC provision 2-301. The seller's obligation is to transfer and deliver the goods to the buyer The buyer's general obligation is to accept and pay for the goods. Now, if one party breaches the sales contract, the UCC does provide a remedy to the injured party. These remedies are designed to place the injured party in as good a position as if the breaching party's contractual obligations were fully performed. That's a term known as expectation damages. So when you enter into a contract with another party, you expect that they're going to perform their contractual duties. And if they don't, that's a breach of contract, and the injured party can sue for expectation damages. Hi, Holly. Thanks for joining us. So the best remedy is going to depend on the particular circumstances of the case. The performance of obligations and remedies that are available in the breach of sales contracts are discussed in Chapter 12 of the textbook. So be sure to at least flip through Chapter 12 and look at the UCC provisions. Now, UCC Section 2A specifically applies to leases. You know, sometimes somebody will lease a lawnmower. Sometimes someone will lease a car. So these provisions that we're talking about would apply to a lease for the sale of goods as well. And if you see that second provision there, that 2A 401, that's when it's a breach of the lease. You know, these days people lease cars, they lease all kind of goods, and sometimes there's even an option to buy at the end of the lease. So the UCC does address contracts for the sale of goods and for the lease of goods. So what does the seller have to do? Well, under the UCC, the seller has to deliver the goods, transfer the goods to the buyer in accordance with the sales contract. That is the seller's basic obligation. That is spelled out in UCC 2-301. The tender of delivery requires the seller to put and hold conforming goods at the buyer's disposition and give the buyer a notification that's reasonably necessary to enable delivery of the goods. Sometimes the goods are available at a dock or the goods are placed in a warehouse. The parties may agree as to the time, place, and manner of delivery, but when those goods have been tendered, the seller does need to let the buyer know, hey, your goods are now available at the dock, or your goods are now available at the warehouse. Delivery has been tendered, and that's UCC Rule 2-301. And again, all these UCC provisions are also on the internet. If you Google them, you'll find everything you ever wanted to know about the UCC. What does the seller have to do? Well, the UCC gives the seller who delivers non-conforming goods an opportunity to cure. So if the buyer has purchased 1,000 nails and the seller was only able to deliver 500 nails, now the UCC gives the seller an opportunity to cure that defective shipment. And that means giving the seller an opportunity to replace defective goods. That's UCC 2-508. That cure may be attempted if time performance has not expired and the seller notifies the buyer of his intention to make the conforming delivery within the contract time. So if the contract says the seller has 10 days to cure a defective shipment, then the seller needs to, utilize that 10 days to deliver some conforming goods, complete the shipment. Or sometimes if someone has purchased windows, for a construction project, and when the windows arrive, half of the windows are broken. That's a defective shipment, but the seller has a time to cure, right? Because the UCC wants to uphold these commercial contracts. So that kind of flexibility makes it possible to uphold the contract, and it gives the seller a chance to cure the agreement so that both parties can get what they bargained for. What does the buyer have to do under the UCC? Once the seller or lessor has properly tendered delivery, the buyer is obligated to accept and pay for the goods in accordance with the sales contract. If there's no agreement, the UCC and the common law will always control the transaction. So the buyer has a right to inspect. The buyer has the right to inspect the goods that are delivered, tendered, or identified in the sales contract prior to accepting or paying for them. If the goods are shipped, the inspection may take place after their arrival. If the inspected goods do not conform to the contract, the buyer can then reject them without paying for them. That's UCC 2-513. Any questions about that, Holly?
I'm good. Thank you.
Does that seem fair to you, Holly? So if the buyer has ordered a shipment of goods and the goods arrive, say, at the dock, the buyer sends his or her employee out. Do you think the employee should be able to inspect the goods before they pay for them?
Absolutely.
Yeah, that seems reasonable. And it's what the Uniform Commercial Code is about, is to really be to be reasonable and to really try to uphold these commercial transactions. Thanks, Holly.
Sure.
Okay, what else does the buyer have to do to perform? Pay. Goods that are accepted must be paid for. That's UCC 2-607, Section 1. Unless the parties to a contract agree otherwise, payment is due from a buyer when and where the goods are delivered, even if the place of delivery is the same as the place of shipment. Buyers often purchase goods on credit extended by the seller. Unless the parties agree to other terms, the credit period starts when the goods are shipped. If it's a lease, the lessee must pay the lease in accordance with the terms of the lease agreement. What kind of remedies does the buyer have? Well, if there's been a breach of contract, a buyer who has accepted goods can subsequently revoke her acceptance if she discovers the goods are non-conforming, or if the non-conformity substantially impairs the value of the goods to the buyer. And one of the following factors is shown. The seller's promise to timely cure the nonconformity is not done. The nonconformity was discovered. The nonconformity was difficult to discover. Or the goods were accepted before the nonconformity was discovered, and the buyer and the seller had already assured the buyer that the goods were conforming. So not only can the buyer reject the goods, the buyer can also revoke acceptance if the buyer later learns that the goods are non-conforming. What are the seller's remedies if there's a breach of contract? One is the right to withhold delivery. The delivery of the goods can be withheld if the seller is possession of them when the buyer breaches the contract. Holly, how do you think a buyer could breach a contract for the sale of goods?
By not paying in a timely fashion?
Brilliant. Yes. And suppose the seller finds out that the buyer's business has filed bankruptcy, um, or the buyer's business there's a newspaper article showing that the buyer's business has been destroyed by a tornado. In that situation, the seller could withhold and just keep the goods if the seller is in possession of them when learning about this potential breach of contract or insolvency of the buyer's business. This remedy is available if the buyer wrongfully rejects or revokes acceptance of the good, fails to make a payment when due, or otherwise repudiates the contract. If part of the goods under the contract has already been delivered, when the buyer materially breaches the contract, the seller may withhold delivery of the remainder of the goods. A seller who discovers the buyer is insolvent before the goods are delivered may refuse to deliver unless the buyer agrees to pay in cash. COD, cash on delivery. Okay, let's get back to the buyer's remedies. The UCC provides a variety of remedies to the buyer upon the seller's breach of contract, and you want to know these for the quiz. I think there's a quiz in Module 3. So you'll want to study this slide very carefully, and it's a summary of some of the things we've already talked about, plus additional remedies. So if there's a breach of contract to deliver goods, the buyer can reject the non-conforming goods, reject the goods if they're not properly tendered in a place where the buyer can access them. The buyer can recover the goods from an insolvent seller. The buyer may obtain specific performance. If the buyer is purchasing something, hi Melinda. If the buyer is purchasing something that is extremely rare, possessions of art, like I like Monet. A Monet painting would probably sell for $50 million. If a buyer has purchased a Monet painting, guess what? Monet's dead. So there's no way somebody else is going to be able to paint another painting and replace it. So that means that the buyer, in order to get what they expected, would go to the court and ask for a decree of specific performance. That would be the court ordering the seller to deliver the goods. Monet's paintings are very rare. Van Gogh is the same way. They're both dead. So whatever paintings that they've left behind are extremely rare, and they're also extremely expensive. They can't be replaced. That Monet painting might be priceless to someone. So in that case, the court would order the seller to specifically perform the contract. If the seller says no, they're held in contempt of court and they could be imprisoned. Rare coins, something else that's very unique, like if somebody was to purchase one of Michael Jordan's trophies, right? Those are very unique items. And if they're waiting for that to be delivered and it's not delivered, they could obtain a decree from the court of specific performance. The buyer also has a right to cover. So if we're talking about like a construction project and the buyer needs to obtain, say, 1,000 nails to complete this project, there's a lot of people that sells nails. So if the first seller is not able to deliver the goods, the buyer needs to go seek cover goods from a substitute seller. That way the buyer is not going to incur any more damages because the construction project can't go on. No, you would just need to obtain substitute goods from another seller, and that's called covering. And if it costs a lot more to obtain the cover, then the seller can sue the buyer. The buyer can sue the seller for the damages of having to cover and the additional cost. What other remedies does the buyer have? Well, the buyer can cancel the contract, and the buyer can also sue for money damages. So I think the UCC provides the buyers with some excellent remedies. And because this is all codified in the provisions of the UCC, there's a lot of certainty for the parties who are contracting and their lawyers, because they know in the event of a breach of contract, they'll have these remedies. Any questions, Christy? Observations? Valeria, am I pronouncing your name right?
Hello, can you hear me?
Yes.
Yes, you are pronouncing my name right.
It's Valeria?
Yes.
Beautiful name. Okay. Is everything clear so far as to how the Uniform Commercial Code works and the remedies that it provides?
Yes.
Great, because this will be on your quiz. It could be on 2 quizzes, in fact. Probably in modules 3 and then maybe modules 5.
Would we have to learn the specific UCC codes?
No.
So okay.
That helps. You don't need to know the code number. That helps a lot. And here's a table that summarizes the remedies again. Let's look at a given situation. So if the seller refuses to deliver the goods or delivers non-conforming goods that the buyer doesn't want because it's not what the buyer ordered, the buyer can reject the goods, revoke acceptance, cover, sue for breach of contract, sue for damages, cancel the contract. The seller tenders non-conforming goods and the buyer actually accepts them. The buyer can sue still for damages or deduct the damages from the unpaid purchase price. The seller refuses to deliver the goods and the buyer still wants them. Sue for specific performance. Get an order from the court directing the seller to tender the goods. Replevy goods or recover the goods from an insolvent seller. Okay, let's talk about your Module 2 written assignments. The assignment is on remedies. In our scenario, the buyer and seller have a master contract that is complete and enforceable. The contract is 20 customized parts have been ordered from careful seller by the buyer. The price is $1,000 per part. They are customized with painted advertising for the buyer's needs. 20 of these customized parts have been shipped to the buyer. So how much is the buyer required to pay, Holly?
$20,000.
You are right. You're good at math. So yes, ordinarily the buyer would be required to pay $20,000, assuming that 20 conforming and properly tendered items were shipped. But in this scenario, 10 have been rejected and 10 have been accepted. The buyer has not paid for any of the parts. What can the seller do at this point, Holly?
They can request the money for what has been accepted already.
Okay. What else could the seller do? So if 10 of the painted advertisements have been accepted, but 10 have been rejected, what can the seller do to fix that?
Sue for specific performance.
Oh, let me have Melinda help you. Can you help, Melinda? So in this scenario, the seller has shipped 20 parts. The buyer rejected 10 of them. What can the seller do?
He has so many days to try to correct it and make those rejected be right for what he wanted.
Absolutely. The seller can cure the defective shipment within a number of days specified by the contract. So yes, all is not lost. If that first shipment isn't perfect, all is not lost. Under the UCC, the seller has the opportunity to cure the shipment by sending 10 properly painted advertisements. So if the seller does that, then there's been no breach of contract and the seller has fulfilled their obligations. And then the buyer would then have to pay for all the parts. But in our scenario, the buyer holds all the parts for 10 days and then returns the 10 rejected parts with a message that says they were too large for use. And the buyer intends to keep the acceptable ones and then obtain cover from another company. What can the buyer do, Melinda, if the buyer successfully obtains cover from another company and gets 10 advertisements that are painted correctly? What remedy would
The let's see.
what remedy would the buyer have?
He wouldn't be able to do that because he had a specific contract with the seller.
Okay, so let's assume that number 4 took place on this chart. The buyer had to cover and obtain substitute goods from another seller, and the substitute goods cost twice as much. What could the buyer then do? What do you think, Christy?
I think if the buyer does not allow the seller to cure it within the agreed upon time, then they're in breach of contract and the seller can get the market price versus the contract price and damages, correct? So if it was like $1,000 per part and now it's $2,000 per part market price, they can get $1,000 in damage per covered part, right?
Yes, yes. The buyer's remedy, that's what we're talking about right now, Christy. So yes,
Okay.
under number 6, if the buyer chooses to go with number 4, cover, and the buyer obtains substitute goods from another seller and it costs twice as much, then the buyer can move on to number 6, which is to sue for money damages, which is the difference
Okay.
between the contract price and the higher price that the buyer had to pay for the substitute goods. Does that make sense?
It does. I had the right situation, but the wrong party.
It happens all the time. Judges do it all the time, so do lawyers. So that's your scenario. That's the scenario that we're working with module 4. And you can see there are several issues, the issues that Christy mentioned about the buyer not getting a chance to cure, right? The issue that I mentioned, if the buyer has to pay more to obtain cover parts. So let's see what you're going to be writing about. Well, the seller has the full right to cure any defect in parts within 10 days of notification of the defect to the seller. So the buyer is supposed to give the seller notice of the defects, and then the seller has a right to cure upon receiving notice. If the seller does not cure within 10 days, the buyer may obtain cover parts from another source. This paragraph is not intended to add to or change any UCC remedy. So this is the language of the parties' agreement. It says the seller has the full right to cure any defect in parts within 10 days of receiving notification from the buyer and the return of the defective parts. If the seller does not cure within 10 days of notification, the buyer may obtain cover parts from any other source. This language in the contract does not add to or change any UCC remedy other than to give time limits. So this is what you want to do in your Module 2 written assignment. First, define cover and cure in your own words. In the context of this contract, you will need to cite to the UCC. And then you want to complete the italicized portions of the IRAC table using the scenario and the UCC to complete your IRAC table. And then select a fix for this clause of the contract to make it more clear as to the seller's right to cure. And then explain why you made the fix. Let me see if I can pull up this IRAC table, because you will need to complete the IRAC table as part of the Module 2 written assignment. So let's see if I can pull up the IRAC table. Module 2 IRAC table. Here it comes. The file is being loaded. Excellent. So this is helping us to learn how to use the IRAC method. IRAC is an acronym in which each letter stands for a word and a concept. When we're doing our legal analysis, we want to first identify the issue, find the rules, and then apply them to the scenario to reach a conclusion. So here is the issue. If a seller fails to cure the shipment in time, is the buyer entitled to buy cover goods? And then you would simply cite to the UCC provision on cover and then apply it. How do you think a judge would apply the UCC section? And then what would your conclusion be in our scenario? And you want to then get on Lexis Advance. You can also use Fast Case. Do a general search of measure of damages for breach of contract. Sort to the most recent case. You always want to sort to the most recent case in your jurisdiction. You could search Minnesota cases for the most recent case measuring damages for breach of contract on Lexis Advance. Why their most recent case? Because every case has the potential to change the law, and some older cases have been overruled. So you don't want to cite to a case from 1950 when there's a case on point from 2020. So you want to cite to that case using the Blue Book format, and what damages would be awarded in court according to the case you found. You do not, you need to specify what damages would be awarded according to the case you found. Then you want to apply that case, that judicial precedent, to our case in the seller scenario and whether or not it would be applicable. So you will need to, when you research your case on Lexis Advance, you're going to IRAC the main issue in the case. So you're going to identify the issue the court was talking about in the case that you research. You're going to put in the analysis and the conclusion of the case that you research. So it's like an IRAC within an IRAC. So you're going to have two IRACs right here. You're going to IRAC the case that you research, and you'll also have an IRAC for our scenario, which is in the problem. Any questions about that? Does that make sense, Christy?
Yeah,
And
that makes sense.
do we just go ahead and fill it in here, right? Or just double checking? We wouldn't
Yes.
rewrite it. Okay.
Some people like to rewrite it, but that is not necessary. You can fill in everything that you need to fill in your IRAC table. The only thing that you can't fill in your IRAC table is define cover and cure in your own words. That needs to be in a separate document. It could be at the bottom or the top of the IRAC table. I have seen some students do that. Make a space at the top of the IRAC table and define cover and cure. And then make a space at the bottom of the IRAC table and fix this clause 3 here of the master contract to make it more clear. So that means you only have to submit one document, which is the IRAC table, and you would just answer the other questions, in a space on the IRAC table. Does that make sense?
Yes.
Great. Otherwise, you'll be submitting 2 separate documents. Your Microsoft Word document that answers what a cover and cure is under the UCC, and the Microsoft document that explains the contract fix for clause 3 of the master contract. And then you'll be, the second document will be the IRAC table. Some students do it that way. Just as long as you answer all 3 of those questions. So again, what is IRAC as opposed to Iraq? IRAC is very popular among law students. This says judges and attorneys, but it is a way to show application and analysis in a clear way in the legal community. When you look at a lot of cases on Lexis Advance, you will see that the judge often lays out the facts of the case, and then the judge will lay out the issue. And you really want to focus on that issue, because when you're doing legal research, if your boss says, I need a case about breach of contract, and I need a case about damages from Minnesota, And you want to make sure that the case you find is specifically about damages, not offer, not acceptance, not some other issue. You need to make sure that the issue in the case that you're finding is directly on point with the case that you need to help your client. So the way you would do that is really zero in on what the court says the issue is in the cases that you're researching on Lexis Advance. And then you want to identify the rule that the court is applying. It might be a statute, it might be the UCC, could be a common law rule. Once you know the rule, then you could figure out that that rule will also apply to your client's case. And that is how we use judicial precedents to support our case. So then you would apply that rule to the facts of your case. That's the analysis portion. Sometimes the rule doesn't work. If it doesn't, then you would say that. Then you have to go back to the drawing board and do research and find another rule that does work. Try a new IRAC with a rule that does apply. Missing facts should be typed into the application analysis, saying, you know, it would really be helpful if we knew when our client notified the seller that the goods were not conforming. It would be helpful if we knew when our client returned the defective goods, things like that, because those are facts that you might be able to obtain. And the last step is always to reach a conclusion. You always want to wrap up your legal analysis with a conclusion saying, you know, based on our analysis, we're going to be able to win this case because our client has the remedy of suing for breach of contract and obtaining damages. So that's how you would do your IRAC. Any questions? Does anyone have any experience using the IRAC form? Maybe Christy has used it before.
Yeah, I've used it. I kind of used it today at work too. So it's good. It's easy and it's pretty self-explanatory once you get into it. So
Excellent. So I just showed you the sample IRAC form that's provided in the Module 2 written assignment. You simply download the form, fill in with the applicable UCC rules, and add your conclusion. If you're looking for the rules, they're in Chapter 12 in the textbook. You could also Google Cure UCC and come up with the UCC rule that way as well. All the UCC provisions are on the open web, along with everything else that's ever happened in the eternity of time. All right, so you want to be sure to take a few moments to read the lesson notes for Module 2, Contract Remedies for Business Cases, the importance of grammar and language, spotting grammatical errors. We'll take some time in the upcoming live sessions to look at grammar and to fix grammatical errors in contracts, but it's discussed really well in your lesson notes. So that's all, folks. Your live session question for this week, which will be a graded assignment, is what does UCC 2-712 say? All you have to do is look it up on Google. What does UCC 2-712 say? Type that into the live session answer box. Please be sure to submit the correct answer to get credit for the Module 2 live session. Submit that by Sunday at midnight Central Standard Time. Your Module 2 written assignment, the IRAC table, and the answer to those questions is also due Sunday, April 17th. Yes, I thought that Sunday would be a beautiful day to enjoy the Easter holiday, but no, it looks like you and I are going to have some work to do. If you have any questions, feel free to reach out to me via email. You can always send me a text message or call 702-241-3415. And, you know, I guess if you would work ahead, then those of you who want to can still enjoy the Easter holiday, as long as you have your taxes filed. Any questions, Christy, Holly, or Valeria, before we wrap up?
Nope, I'm good. Thank you.
Have a great week, everyone. Thanks for attending the Module 2 live session.
Thank you.
thank
Thank
you. Have
you.
a good week. See you next
Bye.
week.
Christy. Take care.